I always tell people if we win at this stage, it's like the thing never happened. It's completely not a public record.
I'd say the biggest myth is that it's not a serious hearing. If you hire me, I'm going to work with you to make sure that we don't say anything crazy or bring up anything crazy. The main decision is they're deciding whether or not to issue the complaint. If they decide to issue the complaint, you are entered into the criminal justice system process. The criminal case against you will officially start if the complaint is issued.
Hey everyone, welcome back to Boston Barristers. This is episode 3, and honestly, I've been having a great time with this. It's been refreshing to just sit down and talk through the legal stuff we deal with every day.
Yeah, I didn't think I'd enjoy podcasting as much, to be honest, but it has been fun getting to unpack things that matter, talk a little bit about the law.
Exactly. So today we're diving into one of the lesser known parts of the process, the Clerk Magistrate's hearing, which is actually something that's, I think, almost completely unique to Massachusetts. A lot of people don't even know what it is until they get that notice of a magistrate's hearing in the mail. See, it's not a trial, but it can be the thing that decides whether you end up with a criminal record or not.
Yeah, that's true, Matthew. You know, these hearings are never going to end up in the headlines in the newspaper, but they really do matter, actually. We see them change lives, and it really is your first chance to make sure that you keep a clean record.
Exactly. So before we dive in, don't forget to share this episode with someone who might find it useful and hit that notification bell so you never miss an update. So, all right, Bill, let's talk about Clerk Magistrate's hearings. So first off, I want to talk about what exactly is a Clerk Magistrate hearing.
I'd say I would describe it as a gateway procedure where essentially you are going to be heard in front of the clerk magistrate in sort of a small meeting type situation, and they're going to determine whether or not your case or the case against you is serious enough to basically start the criminal justice procedure.
Yeah, exactly. So it's a way to head off a criminal case before it ever gets to court officially. I mean, it's completely private. I always tell people if we win at this stage, it's like the thing never happened. It's completely not a public record. So how is that different from a regular arraignment or kind of the normal process in a criminal case, Bill?
Right. So in the clerk magistrate's hearing, the rules of evidence, for instance, are very relaxed. It's not a very strict setting. And so clients and attorneys are able to basically provide whatever information they have at that stage to argue against the complaint.
Basically, just in a hearing room with just you, and it's complete, just you. Usually there's a police officer, magistrate, and your attorney, and you're able to cut this thing off before it gets that far. Like they're able to weed out cases where there's no probable cause. They're able to weed out cases where it's just so minor that it shouldn't go through the criminal process. So at the hearing stage, at the clerk magistrate's hearing, what exactly is the clerk magistrate deciding?
So the clerk magistrate is there to decide whether or not there is probable cause to issue a complaint. And that is just the lawyer speak to say, is there enough information here for me to say it maybe happened?
Yeah, exactly.
So it's a very low bar. I mean, they say probable, which we may think of as more than 50%, but in practice, it seems more like all right, well, it maybe could have happened. And they'll issue the complaint based on that. But like you said earlier, this isn't an official proceeding where you're in there in the courtroom with the judge, and if everybody's there. No, it's a smaller hearing that sometimes happens in a separate room that's not even a courtroom.
Yeah, exactly. It's almost like I always explain it as a conference room. It's where it happens in most courthouses. Although there's some that happen in actual courtrooms, but it's closed off. And yeah, probable cause. I usually tell people if someone says you did it, that's probable cause that you did it. Even if there's no other supporting evidence for it, anything like that. It's just some evidence that you did it. So that's technically what the magistrate's deciding. But a lot of times there's also the other background of, should this really be something we should be dealing with criminally?
Exactly, because just because there is probable cause doesn't mean the clerk magistrate has to issue the complaint. Um, in misdemeanors, if the clerk magistrate decides that even though there is probable cause, that the complaint or the issue can be resolved in a different manner, or it's not serious enough to deserve criminal process, then even though there is probable cause, the clerk magistrate can decline to issue the complaint.
Yeah, and you actually did a deep dive on this because I've a lot of magistrates have come to the conclusion that, hey, if there's probable cause, if the police want to go forward with a complaint, I have to. But that's actually not what the law says. They have the right to say, you know what? No, I don't think this should go forward. It's a minor case that we don't want to ruin your life over. So what are the clerk magistrate decides whether there's probable cause. What are some of the things that can happen? What are the decisions the magistrate can make at a magistrate's hearing?
So the main decision is they're deciding whether or not to issue the complaint. If they decide to issue the complaint, you are entered into the criminal justice system process. Um, the criminal case against you will officially start if the complaint is issued. But as we just covered, the clerk magistrate doesn't always have to issue the complaint. If there's no probable cause, they will not issue the complaint. There's also another option, usually used in more minor cases, where perhaps there's probable cause, but the clerk magistrate wants to be merciful or give the person another opportunity. So they'll say, okay, well, today I'm not going to issue the complaint. And if you don't get in any trouble for the next 6 months or 12 months, I'll officially decline to issue the complaint. But for right now, we're going to put it on pause, put it on hold. But as long as you don't get in trouble, then we'll officially decline to issue the complaint. So it's sort of like a probation period. So they can decline to issue the complaint, or offer sort of a probation.
So if they decline to issue the complaint, it's over that day. If there's that sort of middle option you talked about with probation, it's 6 months, and then the complaint is dismissed after that 6 months. What about the third option? If they issue the complaint, obviously that's not what we want to happen, but what happens after that?
So once the complaint is issued, the defendant gets their arraignment date. And the arraignment is the first appearance of the defendant in court, where they have a not guilty plea entered on their behalf. And that's sort of day one, just getting into the system. That's the arraignment.
Yeah, so usually we're given an arraignment date, and it's not that day. It's not going to happen usually that day, but
right.
it's usually a few weeks or a few months out to actually start the process. So what kinds of cases typically go to a clerk magistrate hearing in Massachusetts that you found?
I see two types of cases. Let's say three. I'd say number one is going to be minor, very minor shoplifting cases for people who don't have criminal records. I've seen several of those. Just people who are accused of stealing things from self-checkout lines, stuff like that, very minor theft. Or another popular one is fake ID use among college kids, where it is a serious crime in that they're accused of possessing a forged document. But the police sort of understand the situation on college campuses. So they want to call them in for a clerk magistrate's hearing to get the kids to understand sort of what they've done is wrong. But they usually are lenient towards them. So fake ID, shoplifting, and then also assault and battery on a family member. It has to be very, very minor for it to go to a clerk's hearing, but I have seen that.
Yeah, I mean, I've seen a couple of those over the years, and we won a few of the assault, like the domestic violence type cases. What a lot of people don't understand is that you have a right to a magistrate's hearing in certain cases, and any misdemeanor that was not witnessed by a police officer, you actually have a right to a magistrate's hearing as opposed to them issuing the complaint in the background. So if you receive a charge for certain misdemeanors, you can actually say, no, I didn't get a magistrate's hearing, and that can be a reason to dismiss the case completely. So, but yeah, domestic violence, it's funny because you're not actually given that right, but the magistrate or the police officer who makes the application can decide that they want to give you a magistrate's hearing, even though you don't have a right to one in that situation.
Right.
You've done a few of these across the state. I mean, what do you feel like are the differences between the ways the different district courts handle them?
I'd say the similarities are that it's me, the client, usually a detective on the other side, and then the clerk. They're usually in rooms off to the side of the main courtrooms, although I have done a couple in main courtrooms. Other than that, I haven't seen too many differences. They're usually pretty standard in my experience. How about you?
Yeah, so I mean, 90% of the time, I mean, it's the same thing where the police officer basically just reads the police report. And then the magistrate turns to you and say, do you have any questions for the police officer? Usually it's not the police officer who actually wrote the report. Usually it's a police prosecutor or like you said, a detective, somebody like that. And then you're given the opportunity to ask them questions or present your side of the story or why the magistrate should not issue the complaint. I mean, different district courts definitely do them differently. Some of them still do them by Zoom. A lot of them are now switching to almost exclusively in person, and different magistrates within those sessions do things differently. So the same courthouse could have a few different magistrates and they could all do them completely differently. That's why it's important to have somebody who's familiar with the court, familiar with the people. So who exactly is a magistrate?
I think the best way to describe them is as mini judges. But how would you describe that?
Yeah, so it's a clerk, and it's as far as I understand, they don't even have to be. You don't even have to be a lawyer to be a magistrate.
Right.
But they actually have the power to do these hearings, and then also they issue search warrants. So you see their names on that, but they're the person sitting in the courtroom a lot of times helping the judge during the regular session. Those are the clerk magistrates, a lot of times, who make these decisions on these cases. Today's episode is brought to you by the Law Office of Matthew W. Peterson. If you're facing legal trouble in Massachusetts, whether it's an OUI, a firearm charge, or even just a clerk magistrate hearing, the stakes couldn't be higher. This isn't the time to go at it alone. You need more than just a lawyer. You need a legal team that knows how to fight and knows how to win. That's why people across Massachusetts turn to the Law Office of Matthew W. Peterson. With years of experience in criminal defense, family law, and immigration, we've got the track record and the passion to defend your rights. We've successfully represented clients in some of the toughest situations out there, from first-time offenses to serious felony charges. We've helped people protect their record, their families, and their freedom. So don't wait until it's too late. Visit mwpetersonlaw.com to schedule your consultation or call 617-295-7500. That's mwpetersonlaw.com and 617-295-7500. Because when your future's on the line, you deserve a legal team that's all in. Stay informed, stay legal. Now, back to the show. So let's walk through what actually happens inside the room. So we talked a bit about like the basics. You know, it's not like Law and Order where you go in there and you have, I guess it's not Law and Order, but where you go in there and say, I have a right to cross-examine somebody, and you're going to have this like cute moment in court.
Yeah, no. Like we said, it's not very formal. Most of the time, in my experience, not even in a courtroom. So what usually happens is, just as you said earlier, we walk into the conference room. We're on one side, detectives, police are on another side. The clerk is sitting in front of us, in between us. The clerk will usually ask the police officer, detective, prosecutor to start. They will read the police report most of the time. Sometimes there might be a witness there to testify, and then we get to respond. And it usually goes that way every time.
Yeah. I mean, usually there's not going to be like, motions filed or.
Right, yeah. No motions. There's no jury there. There's no other people in the room at all. It's sort of sequestered. It's just your hearing. Nobody else is in there. So definitely feels private. It feels like a private hearing. Although what you do say in that hearing can be used against you.
Yeah, so it's all recorded through the FTR system. Now not everyone can access it, but if you represent yourself and you go in there and say, "Yeah, I did it, but you shouldn't issue the complaint," and the complaint's issued, then the prosecutor can actually get that recording and show that this was you admitted to the crime.
Right.
So
Exactly.
but as on the other hand, if you get a lawyer involved, then a lawyer's statements can't really be used against you in the same way. So that's one reason I tell a lot of people to have a lawyer is just to protect you from having to go in there yourself and having any statements that are used against you. And
Yeah. It's a smart buffer to have.
yeah, so there's no prosecutor there, right? So there's no one from the DA's office.
Correct. No one from the DA's office. Just usually, most of the cases for me, it's done people with the police department.
Yeah. So what kind of evidence gets shown at these and how like I guess we talked about there's no cross-examination rules of evidence, but what kind of evidence is there?
In my experience, anything you want to show, because hearsay is allowed. So there are not any restrictions on what you can show. It's just the question will be how credible the clerk magistrate will find that. Um, so it's kind of a free for all. You can show whatever you want to show.
Yeah, and usually I tell people you don't really want to show too much evidence. Their obligation is not to decide what the facts are and what's true. Their obligation to decide whether there's probable cause. So unless your evidence is, hey, I have a plane ticket that shows me in Tahiti at the time this supposedly happened, then usually that sort of evidence is not going to be persuasive to the clerk because they're going to say, well, that's why we have juries, right? The jury can decide the facts of your case. I'm just here to decide whether there's probable cause. So how can an attorney actually help someone at a clerk magistrate's hearing?
So first thing, as you were saying, to make sure you don't incriminate yourself. That is the easiest way to get yourself into a lot of trouble and give yourself a big headache. Having an attorney there, they're going to make sure that you only reveal what's necessary at that stage. And I think the big difference that I've noticed between attorneys and self-represented clients is the ability to present the case effectively using different forms of media, photographs, memorandums, things like that, just to present all the information in a clearly organized way. Because I think something that a lot of clients struggle to understand is that these clerk magistrates know nothing about you or your case, and they're hearing it all for the first time in about 5 minutes. So it can be helpful to have an attorney take what could be 10 years of personal history between you and someone else and be able to clearly boil it down in a minute or two so that the clerk magistrate doesn't get overwhelmed. And I find that attorneys, since they're separated from the situation, were able to better explain it to a neutral observer. And I think that is crucial when you're going in front of a clerk magistrate.
Yeah, it's kind of like we speak the same language as the magistrate. We know how to translate what the facts are and what is important into a language the magistrate can understand, and the magistrate will hopefully find persuasive. I mean, not to mention the fact that you've got things like, crimes and elements and things like that, that it can be tough for a non-lawyer to know and to be able to make a persuasive legal argument about a certain element if that's missing to the
Right.
magistrate, as well as what we talked about earlier, whereas you don't want to have to speak on your own behalf because that can be used against you later on. And an attorney, on the other hand, can say the same thing, but it can't be used against you later. When you have one of these hearings, what's your strategy to prevent the complaint from being issued usually?
So I'd say that there's, broadly speaking, two strategies. One strategy I recommend for people who are pretty much caught red-handed and it's a minor allegation. That strategy is the mercy strategy, where we're gonna take responsibility and then we're going to ask for mercy. And when we do that, we're going to tell the clerk magistrate about who you are, your background, your goals, your values, where you've been in your life, and where you're going. And we make sure that they know that if they were to issue a complaint, it'd be a stumbling block in what otherwise is a successful life. So that is one strategy. I mean, legitimately, people can have a one-off, bad night or something, and the consequences of issuing a complaint for something like that would be way too severe for what happened. So in a lot of those cases, we're asking for mercy. Other strategy is there's no probable cause here. In cases where it could be like an identity issue, where somebody says they're saying I was here and did this thing, but it literally wasn't me. I wasn't there. And so in those cases, that's where we're much more aggressive with our strategy, saying there is no evidence here that our client is involved in this situation at all. You cannot find that there's probable cause. But those are two very different strategies, and which one we go with is going to, of course, depend on your individual fact pattern.
Yeah, and I usually find that they're also in conflict too. If we go in there sometimes and start saying there's no evidence here, we're fighting the evidence, there's no probable cause, then the magistrate's going to say, well, it sounds like you need a trial then, because that's not my job to decide whether there's sufficient evidence. And if we had just made and like I've even had a magistrate say that to me, said, well, if you're denying that it happened, then it sounds like you need a trial.
Right.
And the mercies may be your better strategy, even if there are a lot of big questions about the probable cause. I mean, I've certainly had some cases where there's been a really good probable cause argument that's been successful, but I always try to weave in stuff about my client too, to say, hey, here's this person, and this shouldn't be issued against them. There shouldn't be a black mark on them. So have you ever had any cases where your client actually spoke at a hearing and it made things worse?
Fortunately, I have not, because I have heard horror stories about that. So I make sure that my client and I are on the same page as to what will be said at the hearing and who will be saying it.
Yeah.
I honestly ask my clients if they'd like to speak. And if they do, I give them that opportunity. I just make sure that both of us are prepared before we go ahead and do that, because like we were discussing earlier, you don't want to shoot yourself in the foot by having an emotional reaction to something that was said. A lot of times I find that when the police are reading the police report, clients want to respond and to say, well, that didn't happen, or that's absolute crap or whatever. And it's our job to help them overcome that urge. In addition to it probably not helping, we want to make sure the proceeding goes smoothly because we don't want to anger the clerk, because that's the person who's about to make the decision.
Yeah, exactly. And I mean, I've seen a lot of cases where I wasn't there for the magistrate's hearing. They hired us afterwards. And then I get a recording of it, or I get some report from it. Usually it's in the form of a police report from the officer who was there, who says, oh yeah, this guy at the magistrate's hearing admitted that he did it, but he said it was self-defense. Or, he admitted he did it, but, he had some other legal defense, which wasn't really his best legal defense.
Right.
And the problem is that really pigeonholes us, the criminal case itself, where we can't then pivot to a different defense, or we can't say, hey, we want to, it wasn't him, right? Like if they didn't have sufficient evidence that it was him, they had no way to identify him as the person there. Well, he just admitted it was him.
Right. And that's why there are so many potential pitfalls with trying to do these hearings by yourself, because it seems easy enough, right? It's informal. You can present whatever evidence you want. You can show up by yourself. You don't need an attorney. But what you're talking about is exactly the type of thing that people aren't aware of. They aren't aware that if you go into that hearing, you're going to be locked into what you said.
Exactly.
That's why, and they think, like you said, oh, well, I'll just do the step one. And then if I need an attorney, I'll call an attorney. Where if you had an attorney in the first place, you wouldn't have needed step two. So these really are the best occasion to take care of your case. And that's why I recommend an attorney 100% of the time for this.
Yeah, exactly. And I mean, I've had clients tell me that they called up the clerk's office and they said, "Oh, you don't need an attorney for this. Just come in on your own." And actually, the notice that people get says you're not entitled to an attorney. And I'm sure a lot of people do them on their own and are successful. But the
Mhm.
question is, for those other times where they're not successful or something else happens, you can't then go take it back and say, "Well, never mind. I do want an attorney now. Let's just undo that." The mistake's already been made. I still remember my very first magistrate's hearing was in Boston Municipal Central Division, where my client was charged with spilling a beer on somebody's fur coat they wore to a Bruins game.
Okay. Wow.
And it was this crazy case, and like I went all out on it. Like I remember I got an affidavit from my dry cleaner because they were charged with malicious destruction over a certain amount. So they had to show that the damage was worth so much.
Yep.
And I was able to show, no, this could be dry cleaned out. Like, so I got an affidavit from my dry cleaner. And then we showed up in the hearing, the other person didn't even show up. So it ended up getting dismissed anyway. But yeah, so I mean, those are the types of things that these magistrates hearings can come about for, like types of minor cases like that. I've also seen, I had one recently where the victim, who happened to be an attorney as well, just goes into the hearing and starts mouthing off and actually drops an F-bomb in the middle of this magistrate's hearing.
An attorney did that?
Yeah. An attorney did.
Are they still an attorney?
Yeah, they are.
Yeah.
So he ends up
Yeah.
dropping an F-bomb in the middle of this magistrate's hearing, which, so
Nice.
now we're able to use that against him later on. We're able to, that unfortunately didn't go our way. So we're going to get a recording of that and show that, hey, this guy is flying off the handle in
Yeah.
court. So even if you have a dead loser of a case at the magistrate's hearing, a lot of times it can be a good way to get discovery, get the first chance at cross-examining a victim, get potentially try to get some information like that so that you can prepare for it when the case actually goes to trial or goes to litigation. So yeah, I mean, even in the case where you're probably not going to win a magistrate's hearing, it can still be important to have an attorney there to protect yourself. So people often underestimate these hearings. If a complaint gets issued, it means criminal charges and usually a criminal record, even if they're later dismissed. So how do you usually explain to people how big the stakes are here?
I just say they're huge. And it's this weird juxtaposition between the informality of the process and seeming like it's not a big deal, with the fact that this is, as I said before, your last chance to keep a clean record. Because if the complaint is issued, you're going to be arraigned. And when you're arraigned, you develop a criminal record. So it goes on your CORI, which is your criminal offender record information sheet. And so when people talk about background checks, like a basic employer background check, what they're talking about is what is on someone's CORI. And when a complaint is issued and someone is arraigned, they get their first entry into the CORI. And even if that entry or that case is later dismissed or you're found not guilty, anyone can still look and see that you were charged with such and such a crime. And if you want to get rid of that, you have to seal it. And that's a whole separate process, and that takes time. Really, to save yourself the most time, the most money, the most headache, you want to take care of your case at the clerk magistrate hearing.
Yeah, exactly. And what you don't think about is the fact that this is on your record, and if you have an otherwise clean record, this means that now you'll have to answer about that at job interviews potentially. job interviews are going to ask you, well, why were you charged with shoplifting back at this time? And that could mean the difference between you getting the job and someone else getting the job. It could also, I mean, immigration consequences, LTC consequences. So if it's disposed of at a magistrate's hearing, it won't appear on your record. If it does appear on your record, then that could prevent you from getting an LTC, could prevent you from showing good moral character in the immigration context. It can seem very minor when you get that letter in the mail, but it is probably the best chance we have to make a huge impact in people's lives. Are there any stories you can share, of course, without naming names, where a clerk magistrate's hearing really changed the outcome for someone or changed someone's life?
Yeah, I would just say I had one client who was just really in a rough period in their life and turned to alcohol to cope during that period and used a fake ID. And they were caught using that fake ID, and they received clerk magistrate's hearing notice. And by the time that person showed up to the clerk magistrate hearing, they had actually completely changed their life around, because they were somebody who thought that as society tells people, you have to go to university, you have to get a degree, you have to do this. And this person was just struggling with that vision, life, and how he should live. And it just wasn't for him. And that got him really depressed because he thought that he was broken, that there was something wrong with him. But he discovered that just university, the desk job type life just wasn't for him. So he was able to find a career that was much more suitable to him. And so as soon as he made that transition, his whole life opened up for him. He was just a much happier person, realizing that on a day by day basis, actually now enjoyed what he was doing. So by the time we went to a clerk magistrate hearing, this guy had a completely new job. He was living in a new place. And I just wanted to tell the court that he has made so much progress in the months since he received that notice, and that to issue a complaint over, what is a pretty minor infraction, um, isn't just because the consequences of issuing that complaint would be a stumbling block on this man's path of success. So we were able to share that story, and the clerk found it compelling and said, yeah, I'm not going to issue this complaint because I have seen how hard this guy's worked to change his life around. So I'm going to honor that, and I'm not going to issue the complaint. And he just said, good luck, sir. I wish you the best. And so we left. It never got on his record. He was able to continue with his new career, move on in life. And it made me feel awesome.
Yeah.
Just to help him out like that,
Yeah, definitely. I mean, I remember us talking about that case, and that was a huge thing that is really going to make a big difference in his life. The fact that when he got that letter in the mail, he called you up and got you on his side on that case. And now no criminal record. So let's switch gears a little bit. So some quick hits here. So what's the weirdest thing you've ever seen someone try to bring up in a clerk's hearing?
I don't know. Similar to what's the craziest thing I've heard a client say? I haven't heard anything too crazy or weird because, as I said before, if you hire me, I'm going to work with you to make sure that we don't say anything crazy or bring up anything crazy. So I really haven't heard anything yet. But we'll see.
Yeah, I mean, mine's probably that F-bomb in the middle of the magistrate's hearing.
Right.
But it's
Right.
when you talk to people and they get these notices, what's the biggest myth that people believe about these hearings?
That they can easily do it by themselves. And that's sort of like the tragic part of it in terms of everything we've been talking about, how important these hearings are. And people go online, they do a bit of Googling, and they say, all right, I can do that. And, I don't doubt that people can do some research and do a fine job at their hearing, but they're not going to be able to do it as good as they could have if they hired an attorney who's able to devote the time necessary to really present your case at that hearing, but also have the legal knowledge to avoid all the pitfalls that are there. And the most dangerous thing is that you don't know what you don't know.
Right.
So you might have this great confidence going into the clerk hearing about how you're not going to self-incriminate yourself. You're not going to do this. It's all going to be okay. And then you do something that basically shoots yourself in the foot for the criminal case when the complaint's issued. So I'd say the biggest myth is that it's not a serious hearing, that it's something you can do on your own, that it's, quick in and out, no major consequences. That's the biggest myth, is people not taking it as serious as they should.
Yeah, definitely. And the problem is that we get so many calls from people who say, "Yeah, I went to this magistrate's hearing on my own and I lost. Now what can we do?" It's like, "Yeah, I can try to get you pre-arraignment diversion with the DA's office. We can try to fight your case in district court, but really it would have been so much cheaper and so much less headache for you to just have hired us at the magistrate's hearing." And that's not to say that we're always successful at them, but we usually have a better chance of success than someone doing it on their own. And you don't know whether that small or potentially large difference is going to make the difference in your case.
Right. And I think another great point that you raised before was we know how to speak to the clerks and what the clerks are keying in on, right? Because the clerks are trying to listen for like the legal keywords. And when we're able to feed them those keywords, it gives them a ground to agree with us. But if you don't give them those special like magic words that they can cling on to, they say, "Hey, listen, you didn't give me enough here. I didn't hear the words." So knowing how to communicate with the clerk is huge.
You make it sound like you hypnotize them and there's like a magic word that's just going to.
Sometimes.
Yeah, I mean, I think that's the point is that you talk to people and it's like, "Wow, you have this really impressive life story." And they're like, "Really? I didn't know I did. I didn't know that, this was anything special." It's like, "No, it really is." And we're able to present that in a way to the magistrate that can be very helpful for them and very like translated into their language, I think is what I said earlier.
Right. Yeah. Clients don't know their own value sometimes, in terms of, you may assume, like you just said, "Oh, it's not a big point," and you may not even bring it up at the clerk magistrate saying, I mean, I had one client who, until I asked him, he didn't tell me he's a veteran.
Oh yeah.
And I'm like, that's pretty big. That is a factor that we can raise at the clerk magistrate's hearing to get you some favor. You didn't think to raise that before? So yeah, some people, they don't know what they have, in terms of arguments or aspects about their life that will make the court like them a bit more.
Yeah, and I mean, I've won magistrates hearings for even very serious cases that could have, like, we're talking about firearms charges, talking about different things like that. I mean, I've had cases where, somebody was charged with carrying a firearm without a license, carries 18 months in jail. And we were able to convince the magistrate was like, I've got to issue this. Because of the charge, I've got to issue it. But we were able to, because of the work that we did with the officer ahead of time, and I was able to ask the officer, "Well, will you just withdraw this complaint then?" And the officer withdrew the complaint. And that guy was facing a felony, 18 months in jail. You don't know what type of difference a lawyer will make until you're actually in there.
Right.
And like I said, like you said, there are plenty of people who could probably do it on their own, but you don't know until you're in there.
Exactly.
Bill, this is a really solid breakdown. Clerk magistrates hearings might not be flashy. They may not show them on Law and Order, but they're one of the most important steps in the criminal process here in Massachusetts.
Absolutely. And I mean, if you can stop charges before they're filed, that's always the goal, because that's going to save people a lot of stress, money, and potential damage to the reputation.
Yeah, exactly. So if you or someone you care about ever gets one of these notice for a magistrate hearing in the mail, don't wait. Call a lawyer, because once that complaint is issued, everything changes.
And if you're anywhere in Massachusetts, call us. We're here to help.
So thanks for listening to Boston Barristers. We'll see you next time with more behind-the-scenes insights into the Massachusetts court system. Don't forget to share and hit that notification bell so you don't miss any updates from us.
Yes.